Good morning. This is your Kelso Report for Wednesday, February 27th, and I'm your host, Clark Kelso. We have two Supreme Court decisions today. First, the court resolved a circuit split about whether Rule 54's authorization for costs in favor of a prevailing defendant is displaced by the Fair Debt Collection Practices Act, which authorizes costs on a finding of bad faith. Second, the court issued an interesting Article 3 standing decision in the context of the Foreign Intelligence Surveillance Act. The Ninth Circuit has taken in bank a case involving the scope of structural error for habeas purposes, and we have an interesting Ninth Circuit decision involving piracy on the high seas. Let's start with costs and the Supreme Court. Federal Rule of Civil Procedure 54D1 gives district courts discretion to award costs to prevailing defendants, unless a federal statute provides otherwise. Well, quite a few statutes now have provisions dealing with both attorneys' fees and costs, so the issue frequently arises whether those statutes provide otherwise than Rule 54. In Marks v. General Revenue, the statute at issue was the Fair Debt Collection Practices Act, which provides that, quote, on a finding by the court that an action under this section was brought in bad faith and for the purpose of harassment, the court may award to the defendant attorney's fees reasonable in relation to the work expended and costs. The court granted cert to resolve a conflict among the circuits regarding whether a prevailing defendant in a Fair Debt Collection Practices Act case may be awarded costs where the lawsuit was not brought in bad faith and for the purpose of harassment. Now, I think the answer here is pretty obvious, and the court held by a 7-2 vote that the statute does not provide otherwise. The statutory language does not express any intention to displace Rule 54, and both the statute and the rule can exist without contradicting each other. So, a district court may award costs to prevailing defendants in FDCPA cases without finding that the plaintiff brought the case in bad faith and for the purpose of harassment. The bad faith and purpose of harassment provision in the statute is just a supplementary basis for bringing an award of costs. Next, we have an Article 3 standing case. Now, as I'm sure you recall, the federal courts are courts of limited jurisdiction. And most fundamentally, Article 3 of the Constitution limits federal courts' jurisdiction to actual cases and controversies. To implement this limitation, the Supreme Court has created Article 3 standing requirements. To establish Article 3 standing, the plaintiff's alleged injury must be concrete, particularized, and actual or imminent, fairly traceable to the challenged action, and redressable by a favorable ruling. In Clapper v. Amnesty International, the court held that the plaintiffs lacked standing to challenge the constitutionality of Section 702 of the Foreign Intelligence Surveillance Act, which allows the Attorney General and the Director of National Intelligence to acquire foreign intelligence information by jointly authorizing the surveillance of individuals who are not United States persons and are reasonably believed to be located outside the United States. And before doing so, the AG and the Director normally must obtain the Foreign Intelligence Surveillance Court's approval. Well, the plaintiffs in this case were various United States persons and entities whose work allegedly requires them to engage in sensitive international communications with individuals who they believe are likely targets of surveillance. Amnesty International, for example, is in touch with various people around the world. The court held that the plaintiffs lacked standing because their allegations of future injury were too speculative. The plaintiffs alleged there was an objectively reasonable likelihood that their communications will be acquired under the Act at some point in the future. But that wasn't enough for the court, which stressed that threatened future injury must be, quote, certainly impending, close quote. The plaintiffs argued that they had already taken costly and burdensome measures to protect the confidentiality of their international communications, but the court rejected this argument, noting that the plaintiffs cannot manufacture standing by choosing to make expenditures based on hypothetical future harm that is not certainly impending. So the plaintiff's constitutional challenge will have to wait for another day and a more concrete showing of injury. Next, we turn to the Ninth Circuit. The Ninth Circuit has granted a petition to reconsider its panel decision last year in Frost versus Van Boning. The issue in Frost was whether a particular type of error by the trial court was a structural error for purposes of habeas review. The issue will be taken in bank by the Ninth Circuit now. In Frost, a Washington state trial court, misapplying state law, told defense counsel that he could argue to the jury either a duress defense or argue that the prosecution had not proven its case beyond a reasonable doubt, but that it could not argue both. The trial court's theory here was that the duress defense necessarily admitted all of the elements of the crime. The defense counsel argued only duress and the jury convicted. Well, the Washington Supreme Court affirmed the conviction. It concluded that the trial court had erred in restricting defense counsel's closing argument, but the error was harmless. In his habeas petition, the petitioner argued that the Washington Supreme Court should have treated the trial court's restriction as a structural error, not subject to harmless error analysis, therefore requiring reversal. A split panel of the Ninth Circuit disagreed, noting that the Supreme Court has found the existence of structural errors, errors that affect the whole framework within which a trial proceeds, only in very limited circumstances, and that the court had never even addressed a claim such as the one presented in the habeas petition. Absent a clear holding from the Supreme Court that such an error was structural, the majority of the Ninth Circuit panel could not agree that the state court decision was an unreasonable application of clearly established federal law as determined by the Supreme Court. Well, the full Ninth Circuit now has decided to take this issue in bank to determine whether the erroneous limitation of defense counsel's closing argument was a structural error and whether it was then cognizable in a habeas context. Our final case today involves piracy on the open seas. The Alien Tort Statute provides a cause of action for a tort committed in violation of the law of nations or a treaty of the United States. Well, the plaintiffs in Institute of Cetacean Research versus Sea Shepherd Conservation Society sought an injunction to stop the defendant from continuing to commit acts amounting to piracy under the United Nations Convention on the Law of the Sea. The convention defines piracy as illegal acts of violence or detention or any act of depredation committed for private ends by the crew or the passengers of a private ship and directed on the high seas against another ship or against persons or property on board such ship. The plaintiffs here are Japanese researchers who hunt whales in the Southern Ocean under lawfully approved research permits. Notwithstanding the permits, the plaintiff's ships have been hounded for years by the defendant's ships. And the defendant's tactics have included ramming the plaintiff's ships, hurling glass containers of acid, dragging metal-reinforced ropes in the water to damage the propellers, launching smoke bombs and flares with hooks, and pointing high-powered lasers at the plaintiff's ships. Well, rather remarkably, the district court dismissed the action, concluding that piracy is limited to cases involving private financial gain and to cases involving personal injury as opposed to property damage. I think apparently the district court felt uncomfortable simply branding as pirates a group that believes itself to be a defender of whales and promoter of environmental protection. Well, the Ninth Circuit reversed. The word private in the convention refers not to economic gain, but to whether the acts of violence, detention, or depredation are committed by government-authorized ships or are committed by non-governmental private actors. And the convention expressly encompasses property damage as well as personal injury. As the Ninth Circuit noted, you don't need a peg leg or an eye patch to be a pirate when you are engaged in a pattern of violent acts directed at other ships. The court reversed, remanded, and for good measure, reassigned the case to another district judge. And that's it for today's Kelso Report. Have a great day in the law.